Welcome to the broadcast. Now, the Court of Appeal is at this hour delivering a ruling on the appeal by former Kirinyaga gubernatorial aspirant Martha Karua challenging the election of Anne Waiguru as Kirinyaga governor. The ruling is being delivered by the Court of Appeal judges Roselyn Nambuye, Okwengu and Gatembu Kairu. Let's now cross over live to the Court of Appeal and listen in.
Stored in the KM's kits and restricted the order it granted to access to data. There was material, in addition to the testimony of the second respondent, that IEBC did not provide the appellant with the KM's kits because they left Kirinyaga County on 8 September 2017, having been recalled for the fresh presidential election. The court was correct in our view when it stated in its judgment that IEBC had substantially complied with the court order, save for the KM's kit which had been configured, and that the information was confirmed by the deputy registrar. We accordingly agree with the judge when she stated in her judgment, and we quote, "We are told by the first and second respondent that the KM's kit is like a DVD player, such that once the CD is removed, it cannot show anything. I am of the view that failure to avail the KM's kit did," and I think there was a typo, amount to concealing evidence. The court order of 23rd of October 2017 ordered that the access given was to the data in the KM's kits. The SD cards contained the data. The first and second respondent have explained why the KM's kit had to be configured. There was no court order which had been issued to order preservation of the KM's kit. The data was preserved in the SD card. Technology in respect to gubernatorial elections is limited to identification of voters. There is no requirement for transmission electronically. Section 44 of the Elections Act provides for use of technology which enables voter registration, identification, and transmission of results. Section 39(1) provides electronic transmission for results in presidential election. I find that no prejudice was suffered by failure to give access to the KM's kit. The information required to verify the results was adequately supplied and accessed. End of quote. We turn now to the complaint touching on the appellant's electronic and photographic evidence. In her memorandum of appeal, the appellant contends that the judge should have found that respondents were stopped from objecting to the appellant's photographic and video evidence, as the same was referred to in the appellant's evidence and responded to by the respondents in the affidavits. That the judge should have made an adverse inference based on the respondent's failure to make an application to challenge service of the photos and video evidence. That the judge erred in making a finding in relation to the filing of the missing flash disk when criminal investigations were pending before the DPP. That there was sufficient evidence to show that the flash disk was filed, and the judge erred in finding otherwise. Related to that complaint is the appellant's application that was presented to this court on 20th July 2018, seeking leave to adduce additional evidence contained in the said flash disk to corroborate her evidence that there was bribery and canvassing, tampering with ballot boxes, and other acts contrary to law. As indicated, we rejected that application as it would have been tantamount to predetermining the grounds of appeal in relation thereto. We indicated we would give further reasons for taking that course in this judgment, which we now do. In rejecting the appellant's application for additional evidence, we were conscious of the principles governing the exercise of discretion of the discretionary power under Rule 29 of the Court of Appeal rules, as summarized in the case of Mzee Wanjie versus Saikwa. And we reproduce passages from that case as well as passages from the English decision in Ladd versus Marshall. And then we say, we note that the Supreme Court has recently laid down the governing principles on allowing additional evidence in appellate courts in Kenya in the case of Mohammed Abdi Mahamud versus Ahmed Abdullahi. That court cautioned that a party who has been unsuccessful at the trial must not seek to adduce additional evidence to make a fresh case in appeal, fill up omissions, or patch up the weak points in his or her case. Based on those principles, the jurisdiction of the court under Rule 29 of the Rules of the Court could therefore not be invoked in this case where the complaint is that the evidence was available before the election court, but that court declined to admit it. It is not a case of evidence coming to light subsequent to the trial. The question as to whether or not it was rightly excluded is therefore not one that could be answered or determined through an application for additional evidence. It is a question of whether the election court erred in its treatment of that evidence by rejecting it. That is within the province of an appeal and not within the province of an application for additional evidence under Rule 29 of the Rules of the Court. Returning to the issue at hand, the effect of the appellant's multifaceted complaints is that the photographs that were exhibited to the affidavit in support of the petition and the video recording captured in a cell phone should have been admitted into evidence, and the judge erred in excluding the same. At paragraph 18 of her affidavit in support of the petition, the appellant deposed that, quote, "We were informed that the deputy chairperson of the Jubilee, Kirinyaga, who was also the chief campaigner of the respondent, was canvassing and bribing voters at Kangaru Primary School."
All right. There you have it, Judge Gatembu Kairu delivering the judgment based on that particular court case, citing both, that is Governor Anne Waiguru, as well as the petitioner, who is Martha Karua. We'll definitely keep you updated as we continue monitoring that particular judgment.